Court is calling 2025 CR 000220, State versus Jerry Kyler McGee. Can I have parties announced for the record for the state?
We are diving straight into a sentencing hearing that could change everything for Jerry Kyler McGee. He's already pleaded guilty, and now he's staring down a potential 8-year prison sentence. The prosecutor is dead set against probation, and there's a laundry list of other charges looming in the background. McGee is about to take the stand to beg for his freedom, arguing he's a changed man. But is he a victim of circumstance who deserves a second chance, or a master manipulator whose luck has finally run out? Let's find out.
For the defense?
Ron Ross.
All right. Are you Mr. McGee?
Yes, ma'am.
All right. You entered a plea of guilty to count 1. Count 2 was waived without objection. All right. Count 2 was waived without objection. The court found there was sufficient evidence to find you guilty. The court found you guilty. According to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposed to your application for community supervision. They're taking in consideration 2024 CR 007651, 2024 AL 001409, and the following night magistrate numbers: 751980, 751981, 751982, 751983, and 751984. In this case, no PSI was prepared. Defense counsel waived PSI. The court reset it to give parties a chance to have witnesses present if they wanted to have witnesses present. There was no objection to the court requesting the defendant's criminal history. Is that correct, counsel?
That is correct. You actually gave us the option of a PSA or to go forward, and we're going to opt to go ahead and go forward.
All right. So state, you are opposed. Why are you opposed?
What's going on in this week past year, it's resulted in what could reasonably be described as a crime rate. Not the worst crime rate that Bear County has ever experienced. Crime rate.
Just one moment. Excuse me, counsels. If y'all could step back, I'm trying to hear. Thank you. All right, counsel, you may continue. Right. So with regards to the cases that are being taken in consideration, were those offenses alleged to have been committed on different dates?
Some arose out of the same criminal episode. Some are actually not being taken into consideration. That's my mistake. The UUSP is being dismissed for missing witness. The property is being dismissed for missing witness. The PG2 1 to 4 is being dismissed for insufficient evidence because, as far as I can tell, the PG2 substance was not actually tested by the Bear County criminal investigation.
All right. So if you will tell me the cause numbers that are not being taken in consideration but are being dismissed for other reasons so that I can notate.
Start with X 751980.
Okay. Yes.
9975198
Hmm?
Clause number 2024 CR 007651.
Mhm.
And petition 2024 AL 001409 will be rejected. That is an at-large case. I spoke with the complainant in that case, and he is going to be making a prosecution.
All right. So the night mag number that ends in 80, what is the reason for that dismissal?
Insufficient evidence.
And the night mag number ending in 983
Missing witness.
and the cause number, the 2024 cause number,
Missing.
and then the AL number is being rejected. So that, any objection to the court then changing the paperwork?
No objection.
Okay, let's break down what just happened. This is huge for the defense. Several charges are being outright dismissed due to missing witnesses or insufficient evidence. The ones that remain are being taken into consideration. In legal terms, This means McGee won't be convicted of these additional crimes, but the judge can still consider the conduct behind them when she decides a sentence. Essentially, his lawyer just cleaned up his record significantly right before sentencing, making the argument for probation a little more palatable. It's a strategic win, but the big question remains, will it be enough to keep him out of prison?
All right, so what the court will do is the court will remove from the plea bargain agreement that 2024 CR 007651 was being taken in consideration. The court will remove 2024 AL 001409, NITMAC number 751980, and NITMAC number 751983. So then the items that will be, the offenses that will be taken in consideration are NITMAC 751981, 751982, and 751984. So with regards to the offense that's being taken consideration ending in 81, what is the offense date on that one?
81 was, I've got February the 18th, 2024.
All right, and 82
Same date,
and 84?
same date.
All right. And then this, the instant case is October
31st.
31st, 2024.
Yes, ma'am.
All right, state, is there any other criminal history for Mr. McGee?
There is one prior offense. You'll give me a moment.
Yes.
Check the CIC.
All right, and what's the,
500 out of Green County. For adjudication, which he successfully.
all right, and what is the offense date on that? Or the conviction date?
Disposition date is March 31st of 2020,
All right,
and that is all of the prior criminal history which I'm here.
all right, and state, you may continue your argument. All right, defense?
Judge, may I ask my client some questions?
Yes. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Jerry Kyler McGee,
How old are you, Jerry?
33.
What kind of education do you have?
I have a bachelor's degree in biology and a double minor in mathematics and chemistry.
Okay. Have you, what is your work history?
I've worked for myself and as well as a few different laboratories and medical sales companies here in town. And that's kind of what I specialize in.
Here in town, okay?
Yes, sir.
Hold on a minute. A bachelor's degree in biology with a double minor in math and chemistry? And he worked in laboratories and medical sales? This is not the background you typically expect to hear in a felony sentencing. This paints a picture of a highly intelligent, educated man with immense potential and a promising career. It creates a powerful narrative for the defense. This string of crimes is a complete aberration, a temporary fall from grace for a man who is otherwise a productive member of society. The contrast is jarring, and you can bet his lawyer is hoping it makes the judge wonder, how on earth did this person end up here?
Yes, sir.
Have you lived here all your life?
No, sir. I came to San Antonio in 2015 to attend a master's degree program and as well as work.
Did you ever leave San Antonio?
I left San Antonio for 1 year. I went to Waco, Texas for 1 year.
When did you return?
When I returned is when right about December of 2023.
About a year ago?
Yes, sir.
Okay, are you married?
Yes, sir.
When you went to Waco, did your wife go with you?
She did.
Do you have any children?
I have a daughter. She's about to be 2 years old.
And when you returned to San Antonio, did you return with your wife and your child?
I did not.
Why not?
We were getting a divorce.
And where does she live now?
She lives in West Texas.
Do you see your child
I do.
very often?
As often as I can.
Okay, when you returned to San Antonio, were you able to get a job?
No, I was having a tough time finding a job.
Did you have a place to stay when you moved here?
I did.
Okay, and so how did you get into, you've had several incidences here. Most of them are misdemeanors or they're state jail felonies, small things, but how did you get into doing three different instances? How did you get into that?
I've just fell into the wrong crowd, and I take full responsibility for my actions. I shouldn't have been hanging around the people that I was with, and committing the same crimes that I've been charged with.
And there it is, the classic courtroom explanation. I fell in with the wrong crowd. He says he takes full responsibility. But in the very next breath, he blames the people he was hanging around with. This is a critical moment. Judges have heard this story 1,000 times. While his circumstances, a divorce, unemployment, are certainly tough, the judge has to decide if this is a genuine explanation for a temporary lapse in judgment or if it's just a convenient excuse to deflect personal accountability. What do you think? Is he being sincere, or is this just a performance to avoid prison? Let us know your thoughts down in the comments.
I was down on my luck. I couldn't find a job, and I was doing anything possible to do what I needed to do to make money. That was wrong of me. And but I know that I deserve probation, and I really know that I can take classes and do community service and be responsible about it. And I know it's something I can complete because I have done it before, and I know I can do it again. I hope the court grant leniency on it for that.
And also a job, you need a job. Are you going to be able to get a job?
Yes, sir. Yeah. Yes.
One way or the other, you're going to have to work. If you can't get a job in your field, you're going to have to get a job.
Yes, sir. Yes,
You
sir.
willing to do that?
Yes, sir, I am.
You understand if you're given probation, you mess up, you come back, you're going to go to prison.
I do, and that will not happen.
Have you ever had probation except the one case 10 years ago? You ever had probation?
I've never been in trouble in my life. Sounds like.
Whoa,
Yeah,
stop the tape. Did he just say, I've never been in trouble in my life? His lawyer literally just asked him about the probation he completed 10 years ago. And we started this hearing with a judge listing off a whole slew of recent charges. This is a massive self-inflicted wound. It makes him look either dishonest or completely oblivious to the gravity of his situation. You can't stand in front of a judge asking for mercy and simultaneously try to erase your entire criminal history with a single unbelievable statement. This is the kind of comment that can destroy a defendant's credibility in an instant.
You ever been to prison?
I've never been to prison, no, sir.
Never been to jail more than a few days on these cases?
No, sir. This is the longest time I've ever been in jail, a little over 3 months.
Yeah. What is the situation on your divorce with your wife? Has anybody filed?
Yes, filed. So we're currently, when I get out of here, it'll be finalized.
You're asking for probation.
I am asking for probation. Yes.
Probation's not easy.
I know it's not easy, but I am a strict man. I've decided this is not for me, and I understand that I can't complete it. I come from a great family. I've got a great backing behind me, a great family behind me, and I know it's something that I can complete with in a timely manner and complete it successfully very easily.
Judge, I would ask you to give him probation, and I'd like to point out that the cases that we're going forward on.
Just one second. Do you have any questions? All right, I have a couple of questions.
Sure.
And here we go. The judge is stepping in. She heard everything we just heard. The contradictions, the excuses, and the pleas. A judge's questions are never random. They're scalpels designed to cut to the fluff and get to the truth. She's about to zero in on his mindset, and based on her tone, she is not pleased. Defendants often think the hard part is over once the lawyers are done, but an engaged judge can be the toughest questioner in the room. His entire fate now hangs on how he answers these next few questions. This is the moment of truth.
Sure.
You said you deserve probation.
Sure.
What does that mean? That you deserve probation?
I feel like it's something that I deserve. have not, my past history has shown that I have not, committed crimes, my whole
I
life.
just find that sort of like a weird
No, I would
statement,
appreciate, it's probably a better
Yeah.
word for it. Yes, ma'am.
because you know,
It's
people,
something I don't deserve.
yeah,
Yeah. I
because
get what
people
you're saying.
deserve, in Bear County, people deserve people not to commit crimes,
Yes,
right?
ma'am. Yes, ma'am.
All right, we're gonna go off the record.
What a powerful ending. The judge completely dismantled his argument with one simple question about the word deserve. She pointed out that probation isn't something a defendant is owed. It's a privilege. She reminded him that the community deserves to be safe from crime. In that single exchange, she exposed a sense of entitlement and shifted the focus back to his accountability. We don't see the final ruling, but that correction was a masterclass in judicial authority. Jerry McGee came in with a story of a highly educated man who made a few mistakes, but his own testimony, filled with contradictions and misplaced confidence, may have been his undoing. The judge's final words leave little doubt she was not impressed. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.